panels that we're going to be doing throughout the year. The reason why we did this is because it occurs to us that a lot of real estate brokers spend more time in their offices and their desks, that's just the nature of their job, than when they were out selling or renting real estate. And the great news is that we give you guys a chance to come out here, kind of flex those muscles one more time, get to know each other. Also, as I walked around the room today and I started talking with a lot of the brokers who are here in the area, I got a lot of enthusiasm. There's a lot of enthusiasm for what's going on in our market. I'm enthusiastic. Jesse? Thank you. I'm enthusiastic about it because for the first time in maybe 2 years, 3 years maybe, I'm seeing a lot of people, a lot of brokers start to look into the business, looking at the business instead of just working on the business, because it was just so busy for the longest time that was the case. We just didn't have to do some of the things that we're doing. And of course, we're all aware that over the last 6 months, we had a tropical storm, Debbie. We had a hurricane, Helene. We had another hurricane, Milton. We had a major settlement. We had a major election. We had a major holiday. Let's just take a break. Can we all agree that we're all just going to take a break from all that craziness? And so I also want to say that I'm enthusiastic about the market because as we go outside today, it occurs to me that we live in a beautiful place. I was talking with Tess. Tess is new to us. She's just come in from Breckenridge, Colorado. Is that right? Yes. How cold is it there? Frigid. It is frigid today in Breckenridge, Colorado, as advertised. So tell all your friends, the truth is that people are going to continue to come to Florida. Florida is going to continue to be great. As long as we can stay above sea level, we're totally fine. And I think that that's going to be happening, okay? So what we're going to do today is we are going to have a panel. We're going to cover a lot of different topics that we feel are pretty important for you guys. What I would like to do before we start is that I want to introduce you to our attorneys. We are going to have a chance for Q&A as we approach the end. I'm going to make sure that we save some time for that with these guys, but these are some of the top legal minds in the area, and I've been blessed to know almost all of them for a very long time. And so if it's all right, I'd like you guys just to introduce yourself, and Ms. Coldiron, if we could start with you.
Good morning, everyone. How are you? I'm Natalie Coldiron. I'm an attorney. I handle residential real estate closings. I just opened up my own law practice on April Fool's Day this past year. Yeah, and the exact office that my father practiced in for over 40 years, following in his footsteps. I never take any of these opportunities for granted to present to you what I'm seeing out in the world and the real estate community, and I'm grateful to be here. Thank you for having me.
Good morning, Cindy Riddell, Riddell Law Group. I do mostly residential real estate title insurance transactions, buyer-seller representation, and commercial transactions every so often. I too worked with my father, Jeff Riddell, and have essentially taken over the practice. I'm the principal there now. And I too, I'm very enthused to see all of you here early this morning. I think you cannot get enough education. So hopefully you guys have a lot of takeaways. Hopefully we learn a lot of stuff too from you today. And I think we need to just continue the discussion because it's a great opportunity to learn and improve and elevate the practice that we're in. Sorry.
Morning. My name is Jill Bowen. I am a attorney with Berlin, Patton, Ebling. I practice about 50% residential, 50% commercial, and some condo development thrown in there as well. I am not a second-generation lawyer. I don't think my dad had ever spoken to a lawyer before I went to law school. But I've been in Florida my whole life, born and raised in Inglewood, and just love being in this practice area and love working in Sarasota and in real estate. So thank you for having us.
Hi, I'm Ryan Featherstone. I'm with the law firm of Dunlap and Moran. I do criminal law and personal. I'm just kidding. I do real estate law as well, mostly residential and a lot of commercial as well. Yeah, Dunlap and Moran's been in the market for over 30 years. I've been in practice about 20. I luckily don't work with my father because we kill each other. He's not an attorney, but he is a real estate investor. But anyway, glad to be here and looking forward to this.
And I'm Alex Crum. I have been involved in this association, first the Sarasota Association of Realtors, and then into this association for the last 19 years. I got licensed on my birthday when I was 26, had no idea what I was doing. I learned a lot about what I'm doing from panels just like this in this room. I was the president of this association in 2021. We are actually blessed today to have another president with us, Ms. Debbie Reynolds, who is the current president of the Realtor Association of Sarasota and Manatee. One of the things that I love about this association is that we are big. How many members are we currently? Over 9. We are over 9,000 practicing realtors here in our area. So there's a lot of us, and yet you guys have it straight to the top, and that's consistent in this building. This association absolutely listens. We want you guys to do well, and I believe in my heart of hearts, having been a part of lots of realtor associations, having been a director with Florida Realtors, having traveled the country doing things like this, is that this is the best association and the association that listens to its members more than any other association in the country. So if you have any complaints, Ms. Debbie Reynolds. All right, let's get started today. So we talked a lot about things that have changed in this business over the course of the last 6 months. And guys, it's a lot that has changed in this business. We are going to talk a little bit about the NAR settlement today, which reminds me that we should probably talk a little bit about antitrust and compensation because we are all members of different companies here. And so I will get to that. We are going to start with some different disclosures and some other things that have changed that we need to be conscious of. And a lot of those things, I think for a lot of us, kind of flew under the radar. They just got overshadowed by the really big whale that's out there swimming with us. But before I do that, let me just say that the Realtor Association of Sarasota and Manatee is a not-for-profit trade association devoted to improving the business conditions of the real estate industry. RASM meetings and events often include real estate professionals and other industry stakeholders who compete with each other or work for competing businesses. RASM is committed to conducting all meetings and events in a professional, ethical, and lawful manner, including adherence to all antitrust laws. To that end, the topics for meetings and events shall focus on advancing the interests of real estate professionals and consumers of real estate services, increasing competition, reducing risk for all parties involved in real estate transactions, we're doing that today, and sharing insights on business best practices. The following discussion topics are always prohibited. Agreements to fix prices, just don't do it. Limit product or service offerings. Allocate geographical territory or customers, and refuse to deal. Any discussion inconsistent with this policy will not be tolerated. We're going to be friendly about it, but you're going to get a reminder. Okay? I love it. You guys ready to get started? All right. So, of course, NAR settlement, we have big things afoot. Other disclosures that have just changed or have been included or added are some really big things. Why don't we start on this side of the table? Mr. Featherstone, if you could just let us know some of the things that have updated and changed that we should be making sure that we're taking care of.
As a result of the NAR settlement, sure. As you guys all probably know, as a result of that, As a result of that settlement, you guys obviously have a lot of new forms that you are navigating through and hopefully becoming more familiar with as the time goes on. This is all new for everybody. So it's a case of first impression for everybody. Nothing like this has been seen before, but it is something that, you know, you have to deal with no matter what state you're in. In our state, obviously, we have some great organizations that are putting out these forms for you to use. They've been developed, and obviously, you know, they're new, so you know they'll be tested over time. But there's a variety of new forms, so it is overwhelming. It's overwhelming for us too. When they first came out, I was like, they sort of released them in tranches, as you guys maybe were aware, as they developed them. Either that or they just didn't want to overwhelm us with everything at one time, but nonetheless, it was still overwhelming even though they spread it out. There's different scenarios where you have to be comfortable with what forms you're going to be using depending on that scenario, and also, you know, what your broker's stance is. I know you guys are all brokers, what your stance is, and educating your agents as to what position you guys take as to, you know, how you want your brokerage to utilize these forms, whether it's a broker-to-broker situation or a seller-to-broker situation. But educating your agents on these forms, which are all available, reading through them, understanding the language, understanding what scenarios they apply to is essential because, you know, your agents are out there with your name and your liability, so making sure that they're utilizing the forms that are required based on the facts is essential.
Well, thank you very much. I appreciate that. So we have some changes there. We also have some changes to our actual contracts, our actual listing agreements. We have some new disclosures aside from the NAR settlements that we have to make. Can we go through some of those? And I see you leaning forward, Ms. Cold Iron. I'll lean into you then. Sorry, you made the accident of looking interested.
There are a ton of new changes in the contract. One of the big ones is with the condo rider. I think it went from, 3 to 4 or 5 pages now. What's a little concerning is that whoever's completing the condo rider, which should be the seller, not you, is that it's asking the seller whether certain items apply, like the milestone inspection, turnover inspection report, structural integrity reserve study, with no real outline of an explanation as to when it's required. So it kind of puts the burden on the seller to figure out whether it's required before they'll be able to complete it. All I can recommend to agents and brokers is to have, if the seller has any questions about how to properly complete it, have them speak with the condo association or property manager. I don't want to see these completed by agents, because if it ends up being wrong, your seller's going to point to you for having filled it out. Okay?
Now that's,
yeah.
I'm sorry, we see that with the seller's disclosure too, I think, and that's constant.
Yes.
Yeah. It's just know where we are and don't overstep into the practice of law and explaining how these disclosures are supposed to work. And I'll just stop there because I know that one is out there. Okay.
Changes are more about
More, sure, condo, let's talk about flood a little bit.
a disclosure document. It's not an addendum, unfortunately. And I do wish that it was incorporated into the contract. But, right, but now you have to remember to attach it. I believe it's in a different section in your contract preparation software. But everyone does need to be aware of it because it's a statutory requirement. This is not optional. So it would be nice if it was built into the contract. This is where the seller's disclosing whether water intrusion or flood has ever affected the property. And that's a very important question, especially in light of, the recent storms we've had. Even if the property looks fine, if it was affected by water intrusion, or if the seller filed a claim against their homeowner's insurance policy, that could, make or break the deal. Yeah. Yeah.
Right now, we're negotiating something where there was a payout about the flood. Now, if it came from Allstate and there was a payout, does it count against the FEMA? So FEMA gave the money, and once you get the FEMA money, you can't be reading money again, right? It's a one and done on the FEMA. You see FEMA floods, you gotta disclose it, and the property no longer gets.
That's in the flood disclosure. It asks about insurance claims or claims under FEMA, and they should be treated separately. So they're two separate issues.
So if Allstate made the payment, they're okay. If they got FEMA money, then the house can qualify for getting flood money.
In the same instance, in that same storm, they only get FEMA money once. And my understanding is that people who filed claims under FEMA for Debbie were then not eligible for FEMA claims under Helene because they were too close in proximity. So, yeah. Next year would be a different issue. Yeah.
Thank you, Mr. Andrews. We are going to have time for question and answers at the end. No, you're good.
Do you have anything to add, Jill?
Yeah. I was going to say, so on the flood disclosure, when is that flood disclosure required?
Yeah. Sign, but also every single transaction. And the call I'm getting a lot is, what if I'm on the 10th story of a condominium? Doesn't matter, still required. So that's important to note. And the other thing I want to mention about that is it only addresses if you've gotten FEMA money or if you've gotten insurance money. But if you were self-insured, for example, and you had flood damage, right, it's not on that form that you're going to disclose it, but it still does need to be disclosed in a seller's property disclosure or some similar form, right?
So even if we're on a 10th story condo in Lakewood Ranch and you can't even see the water, we still need a flood disclosure. I love that. 31st floor in Miami, same thing, right? Because it's not had anything to do with the realtors. This is Florida statute. Yes, I love that. All right. So what happens then if we fail, Ms. Rydell, to do any of these disclosures? What could that look like for our transaction?
Well, certainly it puts your transaction in jeopardy. What I wanted to address, with these disclosures too, from a broker's perspective and best practices is you guys have to look internally to your processes and your checklists to really make sure your agents have an appropriate checklist. So when they are on listing appointments, that they understand and can convey to potential sellers, for instance, all of these different things that they need to gather, all the appropriate people. So again, like what Natalie said and Mr. Featherstone and Jill, these milestone inspection reports, SIRS, all of these different items, a lot of these sellers may not completely understand. A lot of us have busy lives. We're not necessarily paying attention to every notice, for instance, from the community management people. So if, again, you're getting ready to sell, you've got to kind of go down this checklist so that you know that you've appropriately consulted your customer as to what they need to start gathering. You want to have all this information up front, because if you get into the transaction and you haven't disclosed properly, you've now given a buyer a good legal argument to get out of the contract and receive their deposit, or obviously too, with errors and omissions coverage and being brokers and having business expenses, these are things you need to be concerned about. People are relying on you. These customers are relying on you. And so I think it's good to have an internal process where you are papering your file as to, my agents are, going to a listing appointment for a condominium, or, we've got now this flood disclosure. We've got a checkbox for everything as far as what they've gathered for this listing package.
All right. So let me ask you then about where to get this information, because that stuff does sound like it's kind of tricky to get, and there's a pretty long list. By the time that we pepper in the things that used to have to be included, which are still included, by the way, in the condo rider, things like the declaration of the condominium, the budget, things like that. Now we have more of it that we're peppering together with it. I know that a lot of those things are just available for us to download through the MLS, kind of grabbing onto other agents' work. I'm not sure if that's the right way or not. That is not the right way. See, I actually didn't know the answer.
Don't do that. I had war stories. Somebody say that some other agent pulled it off of, an expired listing or something like that. Don't do things like that. Yeah, that's right. That's right. These management companies typically have a seller's sale package. You need to get everything from the management companies, because they're charged with the duty of having the most recently updated declaration, amended declaration, rules, bylaws, all of these things. You've got budget items, the summary of, the SIRS report, all these things you get directly from the management company. In fact, your seller gets them directly from the management company. Also, we all have this condominium governance form, right, that we have to attach now, so that anybody buying into a condominium understands their duties, the duties of the board, rights of unit owners. So make sure that you're attaching those as well. Again, this is all to make sure that you've got everything buttoned up, and you don't, from a seller's perspective, obviously you want to be completely transparent. You don't want any accusations of not disclosing something later on or during the transaction, because again, it jeopardizes your transaction. So, make sure that we're getting those items from the appropriate parties charged with keeping them.
And I'd love to dovetail on that. Yeah, these disclosures are a pain in the ass. We all know that. But at the end of the day, it's what's the purpose of them? It's to, like Cindy was saying, it's to be transparent. It's to get all the information out there so everybody involved in the transaction can make an educated decision on whether or not the buyer is going to buy or what have you. At the end of the day, Florida is a litigious state. I deal with people that relocate here all the time that are like, oh, we can't close on the closing date. No big deal, right? I'm coming from Virginia, where I just, hosted the sellers for dinner last night. I mean, no, it's not like that here. It's unfortunate. I mean, we do also have, traumatic events like hurricanes, things like that, that directly impact our market. So it is the transaction that's at risk, but it's also litigation after the fact. So the more that's disclosed up front, the cleaner your transaction is, the less risk there is that you, as the broker, will be getting a call after the fact that, you know, hey, the sellers didn't disclose this recent flood during Helene or blah, 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 blah. Well, now we have a flood disclosure that's supposed to address that, along with the seller disclosure that has applicable language on that too. So the purpose is not just to be, you know, tedious. It's to put all the information out there so everybody is fully aware of the information. When in doubt, over disclose is, you know, so that should be your mantra. But yeah, I mean, I can't tell you and all of us up here how many transactions we close per year where we get a call 6 months later saying, they must have known about this. They must have known about that. Must have known is like tattooed on my brain because I hear that nonstop. Must have known is not good enough to bring a case. You have to prove it. And you know, that can be tough to do. So the more you disclose up front, the cleaner your transaction, the less chance you're going to be paying a bunch of attorney's fees for something that your agent might have done that was negligent or, you know, what have you. So.
Well, what happens then, Ms. Bowen, I'm gonna direct this one to you then. So we have kind of the bigger things, and we talk about things like the milestone report, but we still have a lot of things that need answering on this condo that have been there for a while. Like, does the association have a right of first refusal? Where do we send our checks to? Where can we get contact information? Where should we be getting that information? Is it enough for us to have our sellers fill that out? What if we already know the answer? Can we pre-fill it? Even if we work in that condo association and we are really clear about it, where's the best source then for all of that information? Can we rely on the seller?
So again, we want the seller to be filling that out, right? So then if the seller knows that information, they can fill out that form. We do not want you to be filling it out for them, even if you're sitting right next to them. Like, we'd really rather, you know, you need to have the seller filling that out. The best source for that information is always the association or the management company. As far as, you know, where are we sending checks in the future, that's what your title company attorney's office is going to get with an estoppel. And ideally, they're going to have, you know, that estoppel is going to come with information about where to send all of the, you know, the transfer fee and the application fee and the dues. And that will happen, you know, at closing, and you'll have that estoppel that you can rely on. But yeah, the association, and I know, I mean, there is no one in this room that struggles with associations more than the four of us. I promise you, they're our least favorite part of the job. And so I know that it's easier said than done to ask for that. But yeah, just to protect you, best practice, you never fill that out. You always need to get the information from the association. And honestly, I've seen them filled out, especially for like an investor that maybe has no, maybe they're never there, they're out of state, where they just say, I don't know, right? And even if they're writing that, I'd rather see that than you filling out a guess, right? Okay, I mean, that's not the best case scenario, but it's still better than you guessing on that form. Is that, yeah. I also just want to mention on a practical note, this governance form, I know you're probably all like, what is that and what is going on? This has actually been around since 2022. It is the same for everyone. It's not different for every condo association. You can actually just Google it. As of right now, the one you Google and get from DBPR that says 2021, 2022 on the bottom is the one that you can share. So that's just a practical note, because I've had a lot of agents be like, what is this?
Can you describe what it is?
It's the condominium governance form, and it's a new requirement under the new condo rider that it is disclosed. It kind of. Oh, perfect! I didn't know that. Okay, there you go.
Okay.
It's available in form simplicity.
You don't need to fill out anything.
Nope.
No,
Print it.
no, you just print
So
There's no blanks on
it's a
it.
standard disclosure, like for lead-based paint, here's what you need to know about lead-based paint.
It's
Exactly.
even less, because lead-based paint has to have some information. But this is literally just information. That's it. You don't have to.
You don't put names on it, no association on it, nothing. Just
The flood disclosure actually has the seller sign. The buyer does not sign, but it has the box at the bottom about how it was delivered and obviously when it was, obviously prior to executing the contract, okay? But yeah, there's nothing on this corporate governance form. Don't mess with it. But, you know, again, paper your file as to how it was delivered, okay? Why not?
Why not? Give them the better the paper trail, the better, right? Like, let's make these jobs, their jobs easy for them.
And I just wanted one comment on filling out versus the seller filling out, you filling it out. What seller, yeah, always best. But if you do fill it out, run it by the seller and email it to papering the file, like Cindy keeps repeating, which is true. You know, run it by them, say, hey, listen, I filled this out to the best of my information, including the information you may have given me over the phone. Look at it and make sure that this is accurate and reply to this email confirming that it's accurate. And then print that email and put it in your file.
Know the information or they're returning it to you half complete, you can't accept that. I would then reach out to the property manager and ask them to help complete it because this is a statutory requirement. And the same rules apply for condos where they have to mail this information out to unit owners within 45 days of receiving the milestone inspection report and the structural integrity reserve study. So sellers have constructive knowledge of it, whether or not they opened the mail or received that mail. If your seller's saying that they don't know anything about it, you can't end there. You have to go help them find the information by putting them in touch with the property manager.
Just one thing to point out too, and this is nothing new in the condo rider that was just revised. Item 7, the buyer's receipt. I don't see this enough, and so just a practice pointer, again, confirming receipt of documents. I actually like to write, confirm what's received, maybe have a list with like a red receipt or something, but you really got to document that so everybody in the transaction can understand the 3 days and how to calculate it. So maybe more papering as to delivery of a complete set, and I agree with you. Don't do it piecemeal. Please don't do that because we can't have separate dates, 3 days here, 3 days there. Get a complete package, deliver it with some way to confirm delivery.
Yeah, and you've got a minute probably because your condo's probably not selling in a day. Get it, get it ready. And then don't let them out just by not getting the disclosure.
Just to piggyback on that as well, there is a lot of documentation that the seller has to provide at their expense, which is clarified now as well, because there was a lot, buyers buying it, so shouldn't they pay? Well, no, statute says now the seller has to pay for the production of those documents. They get it back if the deal fails, and the buyer has to pay to replace it if they don't, but it's at the seller's expense. But there's a lot of documentation that they have to produce in order for them to be in compliance, because if you don't produce the frequently asked questions and then 2 days before closing, the buyer calls an attorney and says, I really want to get out of this deal, they're going to audit that and they're going to say, wow, the frequently asked questions wasn't produced. Yeah, it's technical. Yeah, it's ticky-tack, but guess what? They're probably going to be right. I mean, it's not waivable. So, you got to make sure that those documents are produced by the seller. Checklists. They are actively working on a checklist, or our underwriters are actively working on a checklist, and there are some out there like this one from Miami Board of Realtors that actually gives the list of documents that the seller must produce. So again, checklists are great, especially when you're talking about like 8 or 9 documents that have to be produced, including the governance form, which most people, it doesn't have to be edited or customized, so it's easy to forget about.
We're going to shift gears a little bit and start talking about unrepresented buyers. So I am in my 19th year in this business. Prior to August 17th, one time I think I had a buyer, this is when I was 27 years old, said, Alex, I don't think that I want you to be a realtor for me. However, I do want to buy the home. And so they were unrepresented. Since then, 0. And then things changed. Of course, August 17th happens. We get lots of press. Can I just see show of hands, who has had a conversation with a buyer who wanted to be unrepresented in a transaction? Okay, like they're around. And so what then we run into is that a lot of us don't know how to work with unrepresented buyers. Natalie, we haven't heard from you in a minute. Can you talk to us about some of the dangers that we have with unrepresented buyers and some of the things that we can and cannot do when working with unrepresented buyers?
There's a lot of new danger in working with unrepresented buyers because with the new documents that came out under the settlement statement, you have to have a written agreement with buyers if you are working with them. And working with them could include facilitating negotiations, preparing offers on their behalf, arranging for them to see certain properties. So there are a lot of items that you would feel would be administerial, but may require a written agreement under the new settlement statement, or I'm sorry, under the new NAR settlement. It's touchy because working with unrepresented buyers is a lot more work for you. Most unrepresented buyers, I would say, are not savvy with our customs, with the forms, with how much properties should cost. So that's more work on the listing agents to be, bringing them up to speed. But in order to educate them or to provide forms, that starts to cross the line into some kind of agency relationship. Dangers to you would include if you were to refuse to work with unrepresented buyers, it could be considered discrimination or a violation of fair housing laws. So it would not be a good idea to talk to your seller about not accepting an offer from any unrepresented buyers. Anything to add?
I'd like to add to that. So we're all attorneys up here, and we're regulated by the Florida Bar. The Florida Bar makes it very clear as far as our ethics and being able to be cognizant of a client, or for you guys, customers, and what is going on in their mind. So tying that with unrepresented buyers, you guys kind of have to go through an analysis like we do when we have people that we represent, and then on the other side, it's unrepresented, okay? We have to make sure that we're not doing things or saying things that somehow would make that consumer think that we are now working for them and in their interest. So some of the best practices one would do is in writing, confirm anytime you have a communication, or if it's a verbal, follow up with an email, just to confirm that I'm a listing agent. I represent the interests of the seller and not you. So I can only facilitate this part. I cannot, here's a form. I cannot fill out substantial anything, terms, or provide any advice or guidance on what to put in this substantial terms section of this contract. So you have to think how that customer is thinking, sort of the consumer. Whether they're sophisticated, investors, and maybe they think they can do it themselves, or maybe they're just unrepresented because, they don't have, the financial opportunity to, or comfort level to engage with a buyer broker representative. So you got to kind of think, and make sure really make sure that the things you're saying and the actions you're taking aren't somehow convincing that person in their mind that you now work for them.
All right, well,
What do you think about writing an offer on behalf of an unrepresented buyer? Would that require a buyer broker agreement? Yeah.
Can't write for you, but send me an offer any way you can. And we present to the seller whatever was presented to us. If we would like to counter a Florida contract, then we could do that.
I understand from an article that I read from a prestigious law firm that it's okay to provide them with a form, but that the unrepresented buyer would need to fill it out. Because if you're filling it out for or on behalf of them, that crosses the line into working with a buyer. So I agree with that policy. Yeah. Go ahead.
Mr. Wooster.
Excellent. In writing. Perfect.
So I agree with that. I think I want to touch base there because I think, does that absolve us, even as transaction brokers? Ms. Rydell, I know that you had mentioned as we're representing a seller, often we are not representing, and we're all aware that we work as transaction brokers a lot of the time. Even in that case, we get the no brokerage disclosure. Is that sufficient? Can we then, are we free to go fill out an offer at terms presented to us by the buyer?
I don't know if it's very clear under the NAR settlement requirements. You know, yeah, you've got the no brokerage relationship, you papered your file. You know, my concern though is that, you know, do you get a buyer's broker agreement signed, you know, but now you've got this no brokerage agreement as well. So you've got two inconsistent forms right now. So, you know, I would be a little bit concerned, you know, about that.
Yeah, even with that no brokerage agreement, I would not fill out an offer for a buyer.
I wouldn't.
All right.
That's
Is-
still providing your service, and I would not do that.
Is that something that a real estate attorney, if we were to say we can't fill this out, but
Yes.
maybe if you contact
Yes.
an attorney?
That's going to be a lot of your, you know, remedy in all of this too. And certainly pitching for our skills is that, you know, you can always suggest that they hire counsel.
And take yourself out of the loop of liability. Get
Yeah.
them representation. Someone's got to handle their closing anyway.
Right.
All right. So, all right. So just don't write the offer if somebody's looking at, if somebody is interested in writing an offer for your listing, and for whatever reason, there's a lot of reasons. I think we are all aware the primary reason, but the reason why, don't write it. Don't put that liability on yourself. Make sure your agents are aware. And that's, I think, the most important thing, because you guys are here today. Remember that we have 60 or 70 of us in this room today. That gives us whatever 9,000 minus however many of us are not here today learning about this stuff. So make sure you're communicating that to your agents. We're going to do Ronnie in the back, and then we're going to move on. But I will test. I promise we're going to have Q&A. So I'm going to repeat the question because we are broadcasting and recording this. And so the question was that your understanding is that our contracts that are provided to us through Florida Realtors in association with the Florida Bar are copywritten, and we are the only people who are able to fill those out are attorneys and licensed real estate professionals. Is that correct? That's the question? All right, panel, what do you think?
You can Google the forms, but Alex, this might be more in your purview.
Yeah.
That's an ethics violation to provide
My position, and well, I don't know if I should even bring my position. I do have a position. Here's what I'm going to recommend to all of us in this room is that I want you to understand and to have a conversation with your agents, and preferably go out to lunch with an attorney, which I'm sure you guys would appreciate. Go out to lunch with an attorney and pick their brain on working with unrepresented buyers. Understand how you're going to communicate that with your sellers if you're going to make changes to your listing practices with your sellers if you're working with unrepresented buyers, because I do think that you are raising liability in the case that you are working with that. I also think that if you are, I know for a fact, because I've been doing this a long time, that you have an ethical obligation to present any and all offers to the seller. Just because they don't have a real estate agent on the other side, honestly, that would be antitrust. Am I correct? If we were to say, no, we won't work with you because you are not working with a licensee, or you are not even working with a realtor, right? Is that correct? Fair housing as well? Okay. I'd be interested to understand just how that connects, but that's just a question that I would have. Yes. Into the microphone, please.
It can appear discriminating if you are not presenting offers from unrepresented buyers, or turning them down just because they're unrepresented.
What if we're advising our sellers to turn down unrepresented buyers?
You have a duty to present all offers. Many unrepresented buyers actually are investors and very savvy, or maybe an agent in another state. So never discount or question why they're unrepresented. But if they happen to be in a population or a particular demographic where they don't actually have access to certain information. And if that ends up being the case, then you're opening the door for discrimination and violation of fair housing laws.
I also pretty sure that violates the NAR Code of Ethics, as well as on the flip side, whenever you're carving out a market and excluding a market, it violates the NAR Code of Ethics, which I think one of the questions Alex is going to bring up, which is kind of related to that, is can you exclude on the flip side, sellers that are not offering compensation? The answer is no, you can't do that. Even if the seller asks you to, that violates the Code of Ethics as well.
We are definitely going to come to that. If you want to pick it, I would love it if you wish.
Well, I do want to give a little practical tip as well that I've been telling some of the newer agents. I know you all probably have newer agents that are maybe very nervous about they have an unrepresented buyer, they need them to sign this BBA. How do you advise them? One of the things that I would actually have them lean on is the settlement and say, hey, this is the law now. This is what I'm required to do. I can't write that offer for you because it risks my license. So let them use that as something to rely on. Let them kind of pull on that to kind of back them up so they're not as maybe nervous having that conversation with an unrepresented buyer.
I love that. That's great advice. I appreciate it. Now, with that said, say that we actually get to a place where we've done everything, a letter of the law, we are doing just fine. We have an unrepresented buyer who has now gone under contract with a seller who may be transaction broker or single agent, doesn't matter. Either way, there are some things that have to occur. The mortgage financing contingency has to happen. We have to understand where that lies. We have to get through inspections. We have to open the doors and create availability. Are we able to open doors for underrepresented buyers?
Depends.
If it's on behalf of the seller? Okay, so we have the ability to do that, and then I would assume, and I don't know, then just shut up? Is that the best plan? Walk in, wear a big sign that says I'm deaf today?
Well, there's a specific FAQs in the NAR settlement, and I would advise everybody read that and read it again, maybe like once a month, because I too myself, it had been about a month since I read it, and it gives you the specific scenarios like this, talking about ministerial duties. Are you acting on behalf of the seller? Where does it cross the line? So I think it's pretty informative.
So,
Yeah.
But they're allowed to be. A lot of the NAR FAQs leave it up to Florida law to decide.
so on this note, I will say we just brought up FAQs. We have actually provided for you, and if you don't have a copy, we do have extras, both do's and don'ts for working with buyers, do's and don'ts for working with sellers. We're not gonna talk about the NAR settlement just yet, because I want to kind of wrap with that one, because that's going to be the big one, I'm sure. But I will say that we have provided these for you. This is guidance that has come to us through the National Association of Realtors, and this is a part of a bigger series. I gave you the ones that are like relevant for today, but the truth is that there's a lot of really good information at, I think it's facts.realtor. Is that what it is? At facts.realtor. There are printouts very similar to these, covering all sorts of different scenarios. They're easy to digest, they're easy to read, and it will change, I think, your positions on maybe some of the things that you're reading. And it will, because this is new. This is new for a lot of us who are out there. And there's a lot of conflicting facts. There's a lot of conflicting opinions. All right? There are a ton of them. But NAR has kept it as simple as possible for where we are. I will just say on NAR's perspective here is that NAR did choose to settle this. NAR had lost this case already, and they did fight really, really hard to keep things the way that they were. The courts did not agree that NAR was in the right here, and NAR would have gone out of business, which would have affected all of us pretty dramatically. And I'll just say that about NAR. And they are very serious about enforcement here. This is not a good idea. This is the new way, and we have to get on board or we have to get out. And I'll just say that. All right. So unrepresented buyers, what do we do then? In the case that we have a financing contingency date that is coming up. We have our mortgage contingency. Mr. Featherstone, let me direct this to you. Do we, as a listing agent with an unrepresented buyer in the transaction, have an obligation to make sure that the buyer is ready to hit that date?
I don't think you have an obligation necessarily, because you're not representing that buyer. And if you start interpreting the contract to them, you're arguably, representing them or even practicing law. I don't think it's a bad idea at the onset of the transaction, like most people do, to just give a list of deadlines, but is it your obligation to follow up with them and all of that? Now, clearly, from a practical standpoint, you will be anyway, because you represent the seller and you want to know what's going on with the loan and all of that, and you obviously have the right to communicate with the lender pursuant to what the contract says and everything. So from a practical standpoint, I don't think it's going to necessarily be a case where you're not in the know as to what's going on with the loan, assuming the lender is communicating, which is a wild card.
Even in the best case
But
scenario.
do you have an obligation? I don't believe so.
Okay.
Stay out of that loop. You could, or it would be my suggestion that you recommend to the buyer to hire an attorney as the closing agent. That way the buyer is represented and the attorney can help them follow up on deadlines, and that just cuts off your loop of liability right there. You can continue to wear your seller representation hat without worrying about crossing over the line and creating unintentionally an agency relationship with the buyer.
So just to be clear, just to talk about it, so we are accustomed to usually having professionals on both sides of the transaction. And what you're saying is that in this case, if the buyer were to choose to go that route, to choose to select and pay for the title, which we'll talk about title services, that's one we didn't get to, but we should talk about that with closing services. If the buyer does choose that route, would the attorney then be our primary point of contact, knowing that it's different from a real estate professional, but may step into that role? In terms of making sure that the buyer, like the communication should then go through the attorney. If we are, for instance, doing our diligence, we have a single agent, we have a fiduciary to make sure that this transaction closes, either single agent or transaction broker. We have that fiduciary. If we want to make sure that that happens, we need to know what the status of the mortgage is.
I don't know how the panel feels about who communications should be directed to. It's easiest to follow up with the closing agent as to the status of the loan. They often know more about what's going on behind the scenes than the buyer themselves. Yeah.
I'm just hesitant at the idea of the attorney stepping into the role of the real estate agent. And I want to be very clear. I know we are all on the same page up here. None of us want to be real estate agents, right? We like our jobs as they are. And so even if you have someone that calls me and says, I want to be an unrepresented buyer, can you represent me? My answer is yes, I can draft the contract. Yes, I can handle the closing and the title and draft the closing documents. But I don't want to be the realtor, right? I'm not going to inspections. I'm not doing walkthroughs. I'm not coordinating vendors to come to the house. Like all the things that you do and more that I don't even know about, that's not what we want to be doing. And so, and I will do that for you. And I've done it many times since the settlement. If you have someone that calls me and you want me to explain to them all the things that I will not do as an attorney, or that they can charge an hourly rate for us to do, we're happy to do that and try to convince you to go back to you, because we like professionals on both sides as well.
I love that. And you actually, you accidentally stepped into something that's a really good thing for us to talk about, which is knowing your value, knowing what you actually do for the customers with whom you work, so that when you run into that unrepresented buyer, you can say, here are the things that I cannot do for you. If you were to choose to work with me as a real estate professional, these are the things that I will do for you, that I have the ability to do. Here's how I'm going to make your life easier. And then just have some dialogue around that. Is that wise? Just from yeah. All right, just know your value. I think that that's what it was. Okay, Mr. Brink?
Buyer ended up waiving inspections, didn't even know how much the property was worth, had no CMA, didn't get an appraisal. So it was kind of a mess for the buyer.
Well, I would imagine it was a mess for the buyer.
We get put in a tough position where the buyer's coming to us not wanting to work with a realtor. And of course, we want to help prepare a contract and help, get a transaction together. We explain to them what we don't do. We don't do inspections. We don't have access to comps to see whether the purchase price is fair. So we're disclaiming that, we presume you're satisfied with the purchase price that's being put on the contract.
Does that buyer become your client?
Well, yes, yeah, as an attorney.
Buys them. How to go through inspections?
I pitch the benefits of working with an attorney, or I'm sorry, with working with a realtor. And the laundry list of services that you provide that we don't, we're incapable of and don't have time for, don't want to. So I find myself pitching that they need to go find a realtor because I won't be able to help.
No, we all do that. We don't, I can't charge my hourly rate enough to do it. There's no way. We are not equipped to go meet appraisers and meet inspectors and the wealth of knowledge you guys have working with your other vendors too. I mean, it's so, you guys are so valuable. And I think to convince these folks, and you're hesitant, but let's really think about it. We also, as attorneys, would have engagement letters and specific scopes, a scope of engagement as to what services we would perform. So, that I don't know what went on in your transaction.
We
So.
get-
That's what I was,
Get stuck. They want to hire us for these specific limited purposes. So it's either turn down representation or prepare the contract for them.
yeah, that's,
Yeah.
I was going to repeat what Cindy said right there, is that in your case, I don't think there was good communication between the attorney and the buyer. If the buyer came in the door with the expectation that the attorney was going to be the ad hoc realtor, that's on the attorney. Exactly why we have engagement agreements. You niftily call a buyer or seller rep. I have specific engagement agreements that have a very, very detailed scope of work. Also underneath that, I have excluded services. So there's no question that what I'm doing and what I'm not doing. There are some attorneys out there, typically, who like are solos or whatever, that are also licensed realtors. They may do that kind of thing. So there are attorneys out there that will sort of play both roles. And, because of that, maybe that is sometimes the expectation in the market. So it's up to the attorney to let them know exactly what services are going to be provided. I can tell you up here, none of these attorneys nor myself would do that, but there are some attorneys that do.
All right, we have time for one more question, and then we're going to move into the big one. RASM does not produce lists for us to do from a business perspective. RASM will support you in your business, but it's not going to give you guidance on your specific business practices outside of just some really big generals. If it's things, so for our list, so like for instance, when you go to a condo and you're listing a condo, these are the documents that I require. Is that your question? Mm-hmm. Yes. So, and that's, I think, the conversation for the seller. It looks like Ms. Rydell has good input.
Well, it's more of a question too, and this came up in some of the articles that I was reading and preparing for this, is a conversation with a seller from the very beginning before you sign the listing agreement about the potential that we may get an offer from an unrepresented buyer. And again, explaining your value proposition and really detailing it that, you're not only going to be doing all these things, but, there could be other things that, more work, more risk, more cost, maybe it's part of negotiating a certain, amount of compensation, and maybe that's a differential. So just maybe some thoughts on that.
So maybe a wise move would be for you, if you don't already have some documentation in your file that you can provide, which is not something to answer the specific question. To my knowledge, RASM does not have anything like that about here's what an unlicensed person can do versus or an unrepresented buyer. That's not something that we have, and I'll be clear, I don't think that's something that we're likely to have. It's just not, that's not the scope of our expertise here at the REALTOR Association. What we will do is give you access to people who can help you with that, people like our esteemed panel here. But make sure that you have, this is the part, the big takeaway on unrepresented buyers, is that unrepresented buyers are not the same as working in a transaction brokerage relationship. It is not the same. And you do have limitations on what you can and cannot do. Those are not good ideas limitations. Those are legal limitations, correct? Like that open you up to liability, correct? Correct? Like some of you guys might have a field day if you saw an unrepresented buyer. Not you guys. They don't do that work. But maybe people in your field would say, hey, I like this one. This one sounds fun. All right, just an idea there. All right, we're going to move into NAR.
I make
Oh,
one
sorry.
more
Go ahead.
comment about one thing I've noticed, and as brokers, you guys should know this, is that I get calls from time to time from buyers that are unrepresented, that were at a property, that wanted to see that particular property, and the agent was there, whether it was the listing agent or somebody just sitting at an open house or whatever. And they call after, this is the buyer calling, the proposed buyer, and they've finally had a chance before calling me to read what they signed. And they realize that what they signed is not what the agent told them they were signing, because what verbally is being told is, just sign this so I can show you the house. It's just a ticky-tack thing, like, oh yeah, the rules have changed, just sign this. That apparently is going on. So I don't know, you guys need to, talk to your agents about that, because no, it's not just a check the box thing so I can show you the house. And buyers are signing, oh, okay, they're trusting, okay, it's just some ticky-tack requirements so she can show me the house. And then they get home and they read it with their husband or whatever, and they're like, what the hell? And that's when they call a lawyer. So I caution you to educate your agents, not just to be in such a rush. Like, say, yeah, you need to sign, I need to have an agreement with you in order to show you this house, but take some time, go to your car, read this, and then come back and ask, whatever. So, like, they need to understand what they're making people sign. Go ahead.
I love that. So my question then is, so say that I'm a listing agent for a property, that I'm working as a transaction broker or as a single agent with a seller, and that I get a phone call and they say, hey, Alex, I'm unrepresented. I want to stay unrepresented. I'd still like to take a look at your property. Do I have to open the door or make sure that there's access at least for that buyer to be able to get in and take a look at it? And am I able to do that in the first place?
Okay, so you're the listing agent, and you've always had, obviously, your signs in your yard with your phone number, and so it's not unusual for you to have people driving on the weekends looking at houses and wanting to get in. So again, if you're acting on behalf of the seller, I think, my opinion, is that you would be okay. It's, again, are you going to cross that line? And presumably you will, because you're going to get in there and they're going to start peppering you with questions. And then they're going to want to start to talk about terms and negotiating terms. And this happens a lot with our REO agents right now. There are some REO properties, more and more, and we get a lot of buyers just do the weekend thing or go online to the sites and show up. And you have to have those agreements with you. As an agent, you have to really be able to sit down and, yes, you actually maybe suggest they have an attorney before they sign it.
I love that. Thank you. All right. So we really have to move on. We're already about 12 minutes over, which I appreciate. So this next section that we're going to get into, we're going to have questions. I'm just going to tell you outright that if we got questions on the easy ones, we're going to have questions on the big ones.
I forgot to say this disclaimer before we started. We are all attorneys here. This is for educational purposes. None of this is legal advice. This is our own disclaimer. Alex, for
Thank you very
yours,
much.
but this is our own.
You guys are lawyers?
I love that. That's hilarious. All right, no, but that is great. And so we are up here. This is educational, and like I said before, this is brave new world for so many of us who are working here. And the market has been slow for a lot of us. We don't even have a lot of the experience that we require to actually get in and get our hands dirty in this business. Although I'm sure most of us would prefer to have more. What I will say, I would say that that's probably true across the board. Every company, everywhere, always. You're never too busy, except you guys who said you guys like to work too much. Yeah, all right. But so here's what I am going to say is that we are about to ask some questions. I want you guys to approach this, please, just with an open mind and for informational purposes. And if you have questions, hold them for a moment. We are going to run into our Q&A immediately following this section, and we are going to be able to get a lot of your questions answered there. There may be some questions that we aren't able to answer, but we'll cross those roads when we come to them, okay? All right, so let me just start. Under the recent NAR settlement, are bonuses or other incentives to buyer agents, are they still allowable? And let me give you guys an example. I have a buyer that I am working with. I have a showing agreement, and we're going to go look at maybe some new construction. We go into new construction. We find out that they're offering a bonus to buyer's agents. Is that allowable? Can we accept that?
As long as it doesn't go above what the compensation is in your buyer broker agreement.
Okay, so if
Then you get into the topic of modifications, and that'll take the rest of the hour.
we're going to talk about modifications. I promise we're going to talk about modifications. So in the event, then we can accept a bonus. It's not the fact that a bonus, we can take a bonus as long as the total amount received does not exceed what's in our current agreement. Is that correct? That is correct. Okay. Well, then let's talk about modification. Now we run into this situation. Mr. Featherstone, I'll start with you. We run into this situation and we figure out that the buyer, they're going to give us a trip to Fiji.
Interesting topic, because the NAR frequently asked questions takes a different position than the Florida Association of Realtors, as well as the underwriters for our title insurance companies, legal education folks. If you read the frequently asked questions, actually, I think, is it right in front of me? Anyway, they kind of take the position that you shouldn't modify it unless there is a legal basis for the modification, whatever that means. But in Florida, as far as I know, the position across the board, as far as I know, is that you can. You know, if there's a seller offering more compensation than what's in your buyer agreement, you modify it. I mean, obviously you don't unilaterally, you go back to the buyer and you have the discussion, and they have to understand, though, that if that deal falls through, where now instead of 2.5%, they're agreeing to 3% to match what the seller's offering. If that deal falls through and they don't remodify, then on the next deal, they're obligated for the 3%. So, yeah. So, and bonuses or referrals or whatever, it just can't exceed what's in that BBA.
It is clear that it might be a violation if you were to modify your buyer broker agreement to match what the seller is offering. That might be considered a violation. But the incentives and the bonuses having to do with new construction is really throwing me off, because what I thought was to be correct from webinars I've been seeing on FAR and articles from FAR doesn't match the most recent update to the NAR FAQs, where they're saying it has to have a legal basis in order to modify the buyer broker agreement. Everyone's clear that buyers agents cannot receive more than what's in the buyer broker agreement, but new construction incentives change, I think, by the week or by the month. So it would not be possible to have it and match in advance of going to see the property. And if you were to modify your buyer broker agreement because you know you're about to go see a particular new construction home, that would be steering. It could be considered steering.
Can I ask you, can we just define steering for the room? What is steering in real estate?
Steering is selectively choosing which houses you're going to show to your buyer based on the compensation being offered.
Okay, so for instance, if I know and we sit down, I'm at a buyer consultation, is this acceptable? If I say, here's what we are, here is my compensation, I'm going to call the other agents and see what their sellers are offering in compensation. You don't have to see anything where they're not offering. Is that acceptable practice? No. Can you tell me why or why not?
What you want to avoid is, you know, a buyer may sit down with you and maybe they are in a financial position where they're very nervous about this whole compensation agreement and signing it. And they really are going to be relying on seller offering some sort of compensation, to go ahead and cover that expense. Really, you guys need to, educate the buyer that, and again, explain your value proposition that I understand you're nervous, but these are all the homes that fit your criteria. I have a duty, I have, ethical duties to show you everything and not also, potentially be at risk for this possible steering allegation. So I'm going to show you everything and I'm going to package this offer. If it does happen to be that, you find the house that, they're saying there's no offer of compensation, doesn't mean we can't put something in our offer. And I'm going to package this so well and support it with all my CMA and my comps that, I'm going to work hard for you and that's why you hired me, So again, it goes back to that value proposition, but you should not be calling, doing the criteria and then from then they are further filtering, well, this one has the matching buyer broker compensation, amount or percentage or whatever it is. Because again, that you potentially get into that steering allegation. And that's the whole reason we're here, right? We want to start to create those practices and get away from, what, got us here and unfortunately, got the plaintiff's attorneys, really excited and aggressive. So, it's just.
It got them really excited. They got really excited.
And even if there's properties where they're not offering compensation, that just means they're not offering compensation. Doesn't mean they're not receptive to, somebody asking for, a contribution towards compensation. They're just not putting it out there, so filtering based on the fact that they're not offering compensation is silly because that just may be a strategy. They may still be open to it. They just don't want to put it out there that they're offering it.
So two things. Number one is that twice now we've talked about real numbers, and I don't want to talk about any real numbers. So I just want to nip that one right in the bud. What we had talked about in the class, which was the accredited buyer representative, I think that we took, was not the position. I'm happy to talk with you afterwards. The position there was that talk about the options with a seller and let the seller make a decision about how they want to act. And the sellers really have three choices per our listing agreement. They can choose that they want their listing broker to provide compensation, like we did in the old days of 6 months ago. We can talk about that they are happy to provide a credit to the buyer, and they're willing to offer compensation in this much amount, or they can say, we're just not interested in offering any compensation at all. All right, so I think that it's important that we talk about it with our sellers and let the seller make the decision, because we are able as realtors to advertise commission being offered. That is an acceptable practice under the NAR settlement, provided that we don't do it specifically in the multiple listing service. Okay, that's really clear. And by the way, if you're not aware, those are enormous fines, If you do that, they're looking for that. They have logic set up, AI logic, that's just reading through those to make sure that you're not doing it. And yes, they are reviewing every listing that comes through using those tools. And if you get hit with that fine, you can contest it, but they won't let you contest it until after you've paid the fine. Okay, so don't do it. There's just no reason. Just don't do it. But let's talk then about the compensation being offered. So let's just say that the seller does agree that the seller or the buyer's or the listing broker is going to offer a level of compensation. They've specified that level of compensation using either A or B in our listing agreements, okay, to really bring that back. Do we have an obligation to disclose that amount if asked?
Your code of ethics says you need to treat everybody fairly and honestly in the deal. So, I think that, again, it goes back to the original conversation with the seller. The seller might say, hey, I've sold 5 homes with you before. This is how we did it before. It's going to be whatever the seller's circumstances is. And there's different types of marketing strategies depending on whether, their specific situation. And you know, as a listing agent, if you're setting a certain amount or percentage, you know, you may be leaving money on the table, and how, you know, how does that look, you know, for your seller? So again, and you know, they teach us this in law school and in mediation and stuff. The person that throws out the first number, maybe in negotiation, not the best, you know, leverage position. So again, you know, you have plenty of ability off MLS, you know, in your personal social medias and things. You know, a seller may say, bring all offers, you know, and you know, it's another thing you negotiate. Everything is negotiable. You know, closing costs, compensation, everything is negotiable. It's freedom of contract.
Ms. Cold Iron?
According to NAR, offers of compensation must be made by seller in writing in advance of the offers of compensation being made. And in that listing agreement, that is the seller directing you to make that offer of compensation. I don't believe that gives the listing agent the right to start low, and then what's in the listing agreement is, you know, the maximum they're willing to accept. The seller's telling you what offer of compensation to make. And if the seller wants the ability to see what comes in and then be able to negotiate that, then you would check no offer of compensation is being made. And the purpose of having all these options is to put the ball in the seller's court to tell you what offers to make to the world.
All right, I'm actually going to bring up a point. I'm going to contest it just a little bit. I'm going to be that guy that if we check C, seller is not offering compensation, isn't that the same as the seller asking us to say, hey, I'll really take this number, but I want you to advertise it at a higher list price, right? Common practice for sellers. But we can't disclose what that number is. And I think we're all aware, and that's, by the way, I can't recall the term right off the top of my head. But they're required, well, we have limited confidentiality is what I'm looking for, right? So my question then is that if they are saying, C, I'm not offering compensation, does that mean that we have to say that they are not offering compensation? And also, just to bring it closer to where the point that I'm trying to take it, in section B, it says seller is offering compensation in the amount of blank. Do we have the obligation to fill out those blanks?
If seller's not making, or if the seller's not directing you to make an offer of compensation, that doesn't mean the seller's not willing to pay compensation. They just want to see it in the offer. So they're directing you, listing agent, not to publicize any specific offer, dollar amount or percentage compensation. If the seller wants to make a specific dollar amount of compensation, then that would go in the other boxes.
Okay.
I think what you're getting to is the conversation where you check off no compensation, but you're having outside of the four corners of the listing agreement contract discussions about maybe I'll do, maybe. So, you know, again, instead of, you know, even percentages and things, we don't want to get into that. You know, maybe you couch it with the seller as, let's just tell everybody to bring all offers and write in, you know, what you tell us what you want. Again, going back to making the buyer and the buyer's agent, you know, give you that number or percentage to begin with. Because again, we're still trying to get away from the former practices, trying to get away from, you know, language like, well, it's always been, or, you know, this is what you have to do to get. We don't want to get into those conversations because that's what got us here. So, you know, again, explaining to the seller how, you know, how we're going to do this, you know, and that way the buyer and the buyer's agent has to essentially make the first move.
Oh, yeah, that sounds great. That went right to the point that I was trying to get at. As that is an option that is available to you as a strategy for a seller if the seller wants to take that strategy. But again, to be really clear, it should not be us making these decisions. I think, my personal thought, for the sellers. Sellers should always be in control of their own futures. And that's always been the case. That's not new. That's always been the case. Everything is negotiable. Everything is negotiable. All right, so let's talk about fiduciary then, because do I have, if I'm working with a buyer in a fiduciary single agent relationship, if I'm in that relationship, what concerns might I have about not showing properties that aren't offering compensation or where those offers are not disclosed? Am I clear on my question? Okay, so here's my question. I'm working with a buyer. I'm a single agent. I have a buyer that I'm working with in a single agent relationship. My fiduciary, I've had this conversation with the buyer. Buyer says, I just want to keep my costs as low as I possibly can. I want to find the right home for myself. I want to keep my costs low. So I don't want to look at homes that are not offering compensation. Are we crossing into a fiduciary?
Yeah, we kind of covered that, but yeah, you have to, the answer is yes. I mean, you'd be violating a duty and the code of ethics. So you have to show all properties that meet the specs of what the buyer is looking for, regardless of compensation. And again, just as an asterisk, just because those properties are not offering compensation does not mean that that buyer's agent won't get compensation. They're just making you work for it a little bit more. They're not revealing their card. It's not saying, come hell or high water, don't even bring up the topic of compensation. It's, we're not offering it. Offering it is not a prohibition. It's just, we're not offering. Talk to me about it. I'm not offering it, but if you package it as part of what your offer is, I'll consider it.
Yeah, and think of it too. I mean, this is like more of a legal concept. Offer of compensation was always sort of a unilateral contract. This is it, accept it or not. We are not there anymore. Everything's negotiable. So I agree with Ryan. I mean, you've got to show them everything that meets their criteria. I know they're like, but I can't afford it. You don't know that because you're not in the seller's brain right now. And I'm such an awesome agent that you should see the offer I'm about to write and the comps that are going to support it.
Yeah, is it just possible financially that a seller ends up paying a compensation and ends up with a higher net proceeds based on not comping to another offer that might have come in at different price and terms? Yeah, and that might change a seller's mind and incentivize them, perhaps? Yes?
NAR is also clear that it's not okay to filter or sort properties for your buyer based on whether compensation is being offered. And I am hearing some pretty scary stories about agents out there creating Excel spreadsheets with a whole column about whether compensation is being offered. My strong recommendation is to not do that.
Yeah, that's like an amazing document in a deposition that they're gonna bring out in front of you and say, hey, did you prepare this? Yeah.
I also heard that some of the MLSs used to have a filter option for that and that they're removing that. So they've gotten away from it.
That's right. So are we able to advertise? And I don't know if you guys know the answer because this is really an NAR thing. Could we advertise other firms' compensation rates? Yeah, the answer from NAR is no, you cannot.
Yeah.
No, you cannot. The only person who can disclose that, yeah, it is, and it runs into antitrust. And I think that's what we're starting to talk about here, is that it's not just about working with your buyers and a fiduciary. You're really talking about two different companies. If you're not showing, just to make it kind of plain English, if you're not showing properties because they're not offering compensation, then that's two companies conspiring together to raise compensation for those companies. It's competitors working together to cost the parties. That's antitrust? Like that's where we're like straight into it, right? That's not even the kind of law you guys do. They're calling a whole other kind of lawyer. Yes.
I'm
Okay.
just confused. I mean, even if you did advertise what the other brokerages' compensations, I mean, how do you know they don't change the next day or transaction to transaction based on negotiation? I mean, what would be the point? Yeah.
That's like, somebody calling Ryan and saying, what does Cindy charge?
All right. I love that. I guess I'm gonna, at this point, thank you. We're gonna open it up now for questions from the floor. We are gonna bring it back right at the area, and I have another question, which I'm gonna give you guys a spoiler. I want you guys to answer for our big finish, things that you're seeing us out there doing that we shouldn't be doing. So just think about that one in the back of your head. And I'll start over here. Yes, ma'am. Oh, hold on one moment. Can we run the microphone around, Jesse? All right. So for these questions, I'm going to ask that you just hold for the microphone because we are recording it. And this way we can just make sure that it makes it so that everybody can hear it and we can get it, not even just in here. And if it goes in there, we should be okay.
Thank you all for your questions, by the way. We learn from what you're seeing out there. This helps us prepare for future presentations. And this is such a changing animal right now. So this is helpful. Thank you.
And thank you guys for helping us. My question is, you were talking about the issues that you have with buyers coming to you, the issues that they're having with the buyer-broker agreement, that they'll say, I didn't know what I was signing or blah, blah, blah. Can you talk about some of the things you are hearing that buyers are complaining about after signing it and maybe not reading it, what are some of the common things that you're hearing buyers say?
Well, in one particular instance, they thought they were just signing like a showing agreement or something very, very simple that they didn't read the agreement at all because they felt rushed and everything, and they trusted what was told. And then, they read it after the fact, and it was a buyer broker agreement. And so, honestly, I don't remember. But in any event, what I found fascinating was based on what the buyer was telling me. I spoke to the broker and the agent, and they took a totally different position, and we essentially had to buy her out of that agreement. And for a very nominal amount, luckily. But yeah, I mean, that was just the quickest way to resolve it because they totally had different perceptions and positions on what the conversation was and everything. So
And so that conversation centered around the buyer thought that they signed like a shorter term, a less
just
binding
that
agreement
property,
as
just
opposed
that
to like,
day.
yeah, as opposed to an exclusive buyer brokerage agreement, which is
Exactly.
what I assume the form was on the other side.
Absolutely. The other, it was, and the conversation was, no, 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 no. I went through this. Now, granted, the woman who I was talking to was in her 80s, but you don't know. Obviously, nobody was there to be a part of the conversation. It was just the two of them, and so the quickest way to get her out of it was we just dealt with it and moved on. But I think that the message is that these documents are not just simple, again, check the box type documents. Your agents, in a rush to get a deal or just get it done and get the showing and move on to the next thing. They need to slow down. They need to explain these documents. They need to advise them to, at a minimum, take time to read it. Like Cindy said, best advice is, hey, I'm advising you to go speak to an attorney before you sign this. Granted, it's a Saturday. Sorry, if you need to do that and come back another time, whatever. But protect yourselves because just throwing something at them and having them sign it just so you can see the property, that's big risk.
These are new uncomfortable conversations that buyers agents are now having to have with their buyers. Although it should feel like a listing presentation, it's just new and uncomfortable. And all I ask is that you equip your agents with the right materials and spiel so that they can be better equipped to answer uncomfortable questions and not go in afraid to state that this is what you will be paid and we're going to negotiate it in and, just equip them with a spiel.
So I think you hit it right in the head that really when we're having these conversations, it's really almost like a listing presentation, which we are accustomed to having, that none of us are, maybe we're nervous, but we shouldn't be nervous. That's exactly what it is, right? That's exactly right. So it's really not different in practice. It's really all we're doing is changing which party we're working with, correct? You're basically listing a buyer.
My question goes to the open houses then. So if you're going in, I have a lot of open houses. If they don't want to sign anything, what do you do? Well, how do you handle things like that?
So is the question, can I just ask the question again? Do you have an obligation when you're holding an open house to have someone sign a document as they're coming in? Is that the question? Or is if they want to work with you? So for instance, somebody walks into the open house, they say, I'm not interested. You say, but I know one up the street. At that point, are we getting the document signed? What level are we talking about where that
Well,
document gets
either case, you've got people that come in and say, no, this doesn't work for me, and you know of something.
Yep.
So how do you handle both for your listing as well as possibly what else you know about?
Okay.
I think if you're at the open house, you're working on behalf of the seller, right? Because you scheduled it with the seller, you made sure that they went on a long walk with the dog, and the buyer shows up. At that point, you don't have to have the buyer's broker agreement. They see the house because you're working on behalf of the seller. But if they say, wow, this is really great, but it doesn't really meet my criteria, and then they start explaining the criteria, peppering you with questions, and then you, in your mind, you're doing your little, ooh, there's something down the street. At that point, you're crossing the line, buyer's broker agreement time, or maybe the showing agreement for that specific
Mhm.
property. Because again, you have to make sure that you're explaining the value proposition, which is that listing sort of presentation, but buyer's version, but also being so comfortable with these forms, explaining to a nervous buyer, this might be a lot for you, this buyer broker agreement, but there's this other one for this limited, showing of this property, but I can't, I'm listening to you, I really can't continue the conversation. Here's a limited showing agreement, this is what it says, there's this, then we can, continue the conversation about other possibilities.
I love that.
That
So-
circumstance is such a great opportunity for you to show that buyer that, well, I'm working on behalf of the seller right now, but if you would like to make an appointment, I do have some other showings in mind that I could show you. Take this agreement home with you, read it over, call me, and if you'd like to work with me, then I can show you those properties and arrange for that. And they will respect how diligently you're working on behalf of a seller. They'll want that equal representation as on behalf of a buyer.
Love that. Thank you very much. We'll go, yep, sounds like Jesse's got you.
Yeah, it's condominium structural, for villas and one-story condominiums. Is there any structural assessments that they have to undergo for buildings that are 30+ years old? Or is it just for 3 and above?
Only for 3 and above.
So it's only for 3 and above, right, Ms. Bowen? So it's 3 and above. That's not going to be
Residential and
subject to the milestones. It could be that it has some structural things that are separate from that and only on residential. So not when we're selling office buildings.
Yeah, only for residential, and there is a strange, weird loophole for mixed-use condominiums. Like, for example, when the bottom floor is commercial and the rest is residential, we expect that in the next legislative session, they're going to correct that, and that will probably be incorporated.
So and we might see some of that. I don't know how many of those downtown we have right now that meet the age requirement, but we absolutely have that type.
I just got back from real property probate trust law last week, and this is not the last iteration of the condo rider.
Of 10.
Yeah.
Third of 10. I love that. Welcome to Life with Realtors. Let's bring this side of the table. Let's go to Ms. Stoltz, and then we will come back around to you, sir. I do see your hand.
Thank you. This has been great. Question regarding unrepresented buyers. So you're the listing broker. Would it be a best practice to have one of you, attorney, draft up a disclosure that lists what a listing agent can and cannot do for an unrepresented buyer, so that the unrepresented buyer is signing off, it's fully disclosed, so they're fully aware, I can't fill out forms, I can't arrange things for you. Would that be a way to mitigate any legal issues?
There's a form that's close stating that you do not represent them, but representation is such a circumstantial, matter that there's no particular list that would be definitive.
Okay.
Yeah.
Be in the including, basically including but not limited to. And so there'd still be some gray area. So I don't know if you could get the perfect form to include every scenario.
Okay.
That it's almost like a drafting nightmare, don't you think?
I worry about the same thing that came up with Ryan, where they're just not going to read it, right? I mean, you're going to get one sheet, and they're not going to read it, and you're almost in a conversation with them explaining when your services as representing them or assisting them starts.
Okay.
So yeah.
Thank you.
Follow that up with an email after the meeting with,
Reminding them in every preamble should be, as you're aware, I represent the seller, comma, blah, 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 blah.
it's a pain, but every like conversation that has any level of substance to it, follow up with an email. Just to confirm our verbal conversation, this is what we discussed, and hit send.
And hit send. And
Thank
we do
you.
not represent you. Right? You go however you want to do it, Jesse. You can be in charge.
When we're making reference to either our buyers or our sellers about the NAR settlement, are we referring to it as saying it is a new law or is it a new policy? What's the word?
So it's case law. So it's not a law that was like it's not a statute. So it is case law.
It is case law, but my understanding is that because we are realtors, all realtors, there were some exclusions for bigger companies. There are some exclusions that were built into it that had to go back and get settled afterwards. But the overwhelming majority of realtors in the United States are covered under the settlement, provided that we abide by the settlement terms. And if we don't abide by the settlement terms, we open ourselves to further litigation, correct? We lose the protection.
Requirement. A
We
new
lose.
requirement.
Yeah, and that would also be the case, I understand, that would also be the case if we just left the Realtor umbrella, that we might be opening ourselves back up because we would no longer be in the protected party because NAR put that in the settlement. They didn't do that part of it, but they protected Realtors, and if you're not a Realtor anymore, you're just not covered, right? You're now your general public.
Violation could also lead to your loss of MLS access. So just because you're not a part of NAR doesn't mean these rules don't apply to you.
Right.
That's pretty significant to be cut off from MLS.
Question. I do a lot of work out in Siesta Key, and I'm noticing in the write-ups through the realtors, no one is disclosing that the home is flooded. Do we have an obligation as realtors in the description to disclose if the property is flooded? I'm reading these really fancy flowery things. I read the seller's disclosure, the home's been flooded.
So in your scenario, just to be clear, what you're talking about is that in the listing description, the public remarks that you're not saying this home was flooded, but then in the seller's disclosure, or even better, in our flood disclosure, it talks there that the home was flooded. Where does that land?
I think you got to remember too, public comments, Realtor comments, we have a theory under the law of four corners of the document. Whatever's in the Realtor comments, unless you somehow incorporate it into your contract, doesn't matter when you get to the litigation phase of this. So bottom line is, have them do the flood disclosure, have some type of acknowledgement. I've had people hire us before, to memorialize. Everybody understands what's happening. If there's some sort of claim and proceeds, who's getting what, you got to spell it out in writing, everybody signs.
All right.
Also, don't be afraid to disclose that. It's one of those things that it is what it is, and there are particular investors looking for those properties. So it is what it is. Don't hide it. It's going to
Yeah.
come out anyway. You don't want a young family showing up, seeing a gutted house. So I'd say it is what it is, and it will attract a very particular buyer. The house will get sold.
So what I'm hearing is that it's a disclosable thing. You have to disclose it if that house was flooded. We're aware that's actually Florida statute that has to occur, even if it was completely repaired. We have to disclose that occurred, but maybe in the same line that if we know that we have a missing junction box in the attic, that we disclose on the seller's disclosure, but that we would assume is relatively minor, although that's not that minor, I'll burn your house down. Don't do that, right? But we might not put that in the MLS remarks. Okay, I think, sound like we're in the same arena there, at least conceptually? All right, we have time for 3 more questions. Let's do Tess.
2 quick questions.
We'll
This
do
is very helpful.
one over here and then we're gonna come back.
2 quick questions, hopefully relatively simple. Coming back to the condo disclosure, what if the grounds flooded? I watched Juana's initial presentation. I came away from it thinking, yes, you do need to disclose it. And then I'll do my follow-up. Alex, you mentioned they are searching AI documents to make sure that the language is acceptable. My question to you is, who are they?
Stellar.
Stellar.
MLS.
And they're looking at listing agreements?
They're not looking at listing
Buyer
agreements,
broker
but they are looking specifically, they are looking at your MLS listings as you add them to the MLS. And so what they're looking for is they're looking in your public remarks, they're looking in your Realtor remarks, the Realtor only remarks. I would assume, just to be creative, that maybe if someone throws it in the legal description, I would assume that they would figure it out there. Don't do it, is what I'm saying, okay? I don't know exactly what they're looking for and how they're looking for it. I know that they are actively looking for it, and they will tag you without warning. There is no, hey, don't do that anymore. There's, hey, here's this enormous fine. If you don't think that it was fair, we did, and if you don't like it, pay us the money and then tell us about it.
To answer
Okay.
your question about the grounds flooding, whether that has to be disclosed, there was a case, and I believe the home was somewhere near the Everglades, and apparently every single year the grounds had been flooded and the alligators and snakes would then enter the house and be all up in the lawn on a little island while everything around it is flooded. The seller didn't disclose that to the buyer. Buyer bought the home and was shocked when there was a gator and 100 snakes in their yard, as it had been every single year. The court held that, yes, that is something that should have been disclosed, and that was one of the cases that gave rise to this new flood disclosure. So whether this is vacant land, anything residential, even condominiums, if this is something that your buyer would come back on you because seller had knowledge of it and didn't tell you, that may affect marketability of the property. Disclose. When in doubt, disclose.
Are you talking, so you're talking about common elements, right? If you're talking about common elements, don't forget, if it's a 50-unit condo, every owner in there is a 1/50th owner of those common elements. So you have to disclose material facts about the property, which includes 1/50th of the common elements. So yes, you have to disclose it.
Question about there's so many different disclosures. So we've got the BBA, we've got the showing agreement, we've got the pre-touring agreement. And it's kind of like, where is that line that we actually have to enforce the BBA? Because if I'm at an open house and I'm representing the seller and people are coming in, I'm talking about that property, and they're telling me what they're looking for, they take my card and walk out. If they email me asking stuff, I should still be able to freely send them information unless they're saying, now we want to go look at property. Now, where is that where it's like, we just want to see this one house? Do you just do the showing agreement because it's just this one house? If we actually engage in a contract, then we will have to go into a buyer broker agreement, and I will outline, my bonuses of using me and what because the pre-showing agreement already discloses what your compensation is.
Identifying potentially suitable properties is specifically named in the NAR FAQs as working with a buyer. And if it's specifically named in there, then my strong recommendation is to have some form of a BBA signed. Now, which form to use would be a broker decision. I'm hearing most often that brokers are pushing the full-on BBA because it contains the most protections for you as the agents, for you as the brokers. There are other options available, but that's just generally what I'm hearing as to the preferred document. But as far as you hearing what buyer wants and sending them specific properties, that's specifically noted as working with the buyer versus they're on a mailing list and you're sending them showings.
You want to do it?
Or I'm sorry, listings of your own.
All right, let me do one question over here. Is it relevant to this specific topic?
Yeah.
What is the open house that they're looking for? I mean, when they can easily access those same properties through Realtor.com and Zillow, they're just asking me. I mean, half the time they find that stuff outside. I feel like if I go and meet them at the property before we meet, we have that discussion about a buyer broker agreement, what the compensation is, because the new laws that affect my business, because I'm a member of National Association of Realtors, say I have to have this agreement signed by you.
So they're going to start with I need more information from your open house. That's working on behalf of the seller. But then, even.
They leave
and they come, no, I know. And then if you're still searching criteria, they're giving you criteria, all that stuff, just like Natalie said, it's clear in the FAQs, just because you're not opening the door yet, you're going to start, the idea would be you get the criteria, you go on MLS, you start filtering 4-bedroom versus 3-bedroom or whatever the criteria is. That is working on behalf of the buyer.
Love that. Thank you. All right. We have, if it's all right, I have Mr. Featherstone has a question that he would actually like to ask the panel.
Yeah, I just wanted to know, like, what you guys' opinions are, or what you're telling your agents when it comes to whether you want to see the broker-to-broker compensation or...
Oh, we can't get into it.
Oh, we can't?
Yeah, I appreciate that.
All right.
I love it. It's a great question. That's one we can't get into.
Come on.
That's it. That's a lunch question. Take me out. I love it. I'll talk about my position is particular. I'll be happy to do that, and I like lunch. I eat it most days.
Sorry.
No, you're good. You're good. We're not going to go there. We're going to cast a very fine. I love it. That is a great question. It's an important question. If you want to talk about trends, I'll talk about trends separately, not with a microphone. What's your thoughts on the foreign buyer panel?
It's a pain in the ass.
Fair housing briefly, but I feel like it's just a huge issue, fair housing.
It's something that we're stuck with. It's obviously being questioned and litigated as to violation of fair housing laws, but we're stuck with it. That's all we've got to go with.
All right.
Obviously, we don't want you asking people, right? We don't want you to have a very discriminating asking them where they're from or what country or anything like that. But just so you know, our offices all have an affidavit that the buyer is going to have to sign at closing that says, I am not a foreign national of one of these countries that's restricted from buying property in Florida. And we're having that signed at closing. Yeah.
It's specific, actually, it's not foreign national, it's foreign principal, meaning that you're not the minister of the interior of North Korea that's buying a property next to the water treatment plant over by Waterside. So that's the specifics. And we all have the affidavit, but I mean, it's our practice. We send that out like day one because we all want to know at the beginning of the transaction, what are the possible issues. So I think everybody does that, right?
Yeah, I was just going to say that we send it very first communication on both sides, actually, buyer and seller. I mean, knowing the 7 countries isn't, you should know which 7 countries, but the analysis is not for you guys to do. If you deal with somebody from one of those countries that's a foreign principal from one of those 7 countries and doesn't also have dual citizenship or whatever, just call one of us and we'll walk you through it.
All right. Ms. First, and you're going to be our last question for here.
Just a statement. First of all, thank you to all of the members of the panel. I've worked with all 4 of them, and they're such professionals, and this is a delight to have them here. I also want to commend RASM. If you have not looked at the very last line on your handout, it references you to facts.realtor. This is one of the most incredible websites. It has material for you to give to the consumer. It has material for you to give to your agents. It is so comprehensive. So don't forget to use that as a resource to you because it's invaluable. Thank you.
Ms. First, thank you very much. I appreciate you. Yes, you may.
We haven't brought this up, but I feel like I have to say something. The level of cyber fraud that I'm seeing these days is so incredibly significant. I learned in a presentation that if your buyer gets hacked or fake wire instructions are sent to them and they wire out, they're going to lump us all into a lawsuit, and you have to show what policies, written policies you have in place to have prevented that from happening. So if you're not counseling your agent, regularly change their passwords, never handle wire instructions. Don't call the number on the wire instructions to verify the account number. Call the phone number on page 1 of the contract. That tweak alone right there could save your buyer from wiring out hundreds of thousands of dollars. When I say this is rampant, this is no exaggeration at all. They also need to scrutinize the emails that they're receiving and sending to. And what's showing up on their phone or at the top of an email is not necessarily the exact email address that it's being sent from. I recommend forwarding emails and retyping it yourself instead of replying all. This is so significant that I have to say something.
Do not, what you're saying is, and I'm just going to say it very forcefully also, do not email wiring instructions. Get those from a trusted source. Is that correct? Okay, would you guys ever, well, I'm not going to tell you. All right, just in case. All right, here's what we're going to do. We have one more question. I'm going to ask the panel. We're going to do a lightning round. One thing that you're seeing us do that we shouldn't be doing, and that's going to be a chance for you, if you're like, well, I'm actually out there doing that, maybe you come up and you talk to Ms. Bowen. You say, well, let's just hear about that. Before I do that, could I ask that any of the members of our small broker advisory panel who organized this, if you could please stand up for me today? Yeah, I'd appreciate it. Thank you, guys. Have a seat. The reason why I'm asking you this, and I'll give you just a moment, Debbie, I absolutely will. So the reason why I want you guys to do that is because we are going to do this throughout the year. It may or may not be another panel like this, but we're interested in your feedback. So what you liked, what you didn't like, if you would like us to do something. The goal for us is to create far more engagement for you guys specifically. This is a valuable place for you for educational, for guidance. That's why we're here, and we want to be as impactful as possible. For that, if you've got ideas, we're all ears. We want to hear about it. Ms. Reynolds, current president of the Realtor Association.
Yeah, we're going to be going back to the line community where brokers, we're all financing you guys come to us. And so we're going to be going to Paris, North Venice, Miami City, all these different places. If you would like to sit on that passport, please get your cards to me or contact me anyway, because I'd love to have you. Again, it's all about building bridges. That's all we're doing is here to make sure that everybody gets. Again, we've always asked people to come to us. We'd like to thank you.
And maybe if you'd like to invite us into your office or to come be up close to you, we'd be very open to an invitation like that. All right. Thank you very much. I appreciate you guys. All right. All right. Here's our last question, guys. How are we screwing it up? Let's start with you, Mr. Featherstone.
Well, not as brokers, you guys are perfect, but as far as your agents, I guess two things. One is the rushing is a consistent issue because it just, like my example before, I mean, just slow down, explain things, give people time to read. I mean, it never ceases to amaze any of us. I can speak for the other three on the panel that, we get to closing and, or reviewing a closing statement, let's say, and they're like, either side, I'm paying for that, I'm paying for that, I'm paying, what is this title insurance? It's like, it just never ceases to amaze me that they didn't read anything in their contract. So the rushing, I get it, it's a competitive market, but that's definitely something to encourage your agents to slow down. And then also on the new stuff, encouraging them always to send us their comp agreements because we need to make sure you guys get paid right. And, we don't know for sure unless we see those agreements. Now, I mean, obviously an email is fine, but, there's nothing that substitutes for actually sending us the document because you may mistype something in the email or whatever, from your phone or what have you. So, if you can send us those agreements, we keep them confidential. We're not going to share them with anybody. Some offices are going as far as to draft separate agreements or estoppel certificates, which we're talking about doing in our office that we would send out to have the people fill out as to what it is. But yeah, if you can encourage them to share those with us, again, we're definitely going to keep them confidential.
Appreciate you. Ms. Bowen.
I'm going to go back to condo world because that's where I spend many of my days. So I really want you to be wary of providing legal advice as to what is and is not allowed based on your interpretation of the condo documents, especially when it comes to rentals. I get this one a lot. Well, the seller and my agent told me that I could rent this out, every week of the year, 50 weeks a year. Just have me look at it, have someone up here look at it. We ask the association to put it in writing as to what their rental policy is. That would be number one option right there. But then, having someone else look at it, because I do get that a lot. I get it about pets a lot. Oh, well, the agent told me that I could have my 2 dogs here. Well, these documents say that only 1 dog is allowed and it has to be this kind. And, so just don't get into an area where you're interpreting those documents. And then on top of that, with the budget, if your client, especially in these kind of like high dollar condominiums, a lot of times your client is asking you, well, is this a financially healthy association? Are they reserving properly? Don't answer questions about that. Tell them to talk to their CPA, right? Or their accountant, or get someone to refer them to. You always want to send them to an accountant to look at that document.
So what I hear is don't be the source, be the source of the source.
Yeah.
Okay? I love that.
I'm just going to piggyback on kind of both of what you guys said. The rushing, specifically short inspection periods, both from a seller's perspective and a buyer's perspective. From a seller's perspective, I want that buyer to have adequate time to do their due diligence so I avoid the allegation after the fact that I tried to hide something and that's why it was a short inspection period. We mostly write on as is. As is has no permit provision in it, so if you don't write in something and negotiate something like seller will pay and close out also, it's an issue. Now, the FAR Bar Committee is working on writing something in possibly in the future, but some of those short periods of time really put a burden on us. And then, you know, certain things can be discovered that need to be further negotiated, and or your buyer may just be in a position where they can't live with it. And now, you know, if you had given us 10 days, we could have figured it out, but we can't do it in 3. And yeah, don't try to interpret the condo budget. Don't try to interpret the home inspection report or the roof report. Yeah, I don't play home inspector, engineer, or CPA. So.
Thank you.
I can answer your question, but we also forgot to talk about the closing services change.
Sure. All right, tell us what the closing services is, because here's how we're screwing it up too.
Okay, so has anyone ever handled closings in Miami or Naples? It seems to be customary, as far back as I can remember, for the closing agent to charge a settlement fee to both sides. And it's not like $100. I'm seeing $895 or $1,200 to both sides for closing services or preparation of the deed and seller affidavit, and that's it. And my argument was that there's nothing in the contract and Florida statutes. There's no requirement or, you know, right for the closing agent to charge something like that to the non-title paying party who didn't select them. Well, FAR Bar just changed that. They have added into our contract, and it's in the section where it talks about seller services and then buyer services. They've added in to each section closing services charged by the closing agent or a company selected by seller or buyer. And that's problematic in the sense that most agents, especially right now because it's new, aren't going to know that it's there. This means if buyer picks and pays and you represent a seller, your seller could be burdened with a closing charge unknowingly at the closing table or when the settlement statement eventually comes out. The general recommendation to you right now would be to reach out to that closing agent, ask what they're going to charge, and then get that in writing. And then
Before you execute a contract.
before you execute a contract so that you know what your seller's getting into. And then the contract just references a statute. You know, it talks about closing services shall have the meaning ascribed to that term in section 627 of the Florida statutes. Each party bears their own closing charges. Then the statutes define closing services as preparing documents necessary to close the transaction, conducting the closing, or handling the disbursement of funds. I mean, it's very broad, and now it's in the contract that each party has to pay those fees. So there may be title companies, closing agents tacking on a closing services fee to the non-title paying party, and you need to be aware of that and come up with a way to avoid your client from being charged with that.
I love that. Thank you so much, guys.
Yeah.
We are at time. In fact, we're just a little bit over, and I appreciate your patience with us. Guys, can I please get a really big round of applause for our panelists today? Guys, thank you very much. Oh, no, they got to take me to lunch. That's how this
We
works.
don't eat. We don't eat.
It'll eat. All right, guys, thank you very much. I'm around in the room however you guys like to do it.